versus the Administrative Office of the Trial Court, SJC-10584.
Good morning, Mr. Powers.
Good morning, Your Honor.
Thank you.
May it please the Court. My name is Kevin Powers, and I represent the plaintiff appellant in this case. This case came directly from the Superior Court to this Court. The trial court allowed the defendant's motion, which was filed under Rule 12C, and dismissed all 4 counts of the plaintiff's complaint. The basic facts in the case are that Stephen Anzalone, the plaintiff, received a Bachelor of Science degree from Northeastern in 2003. In 2006, he applied for probation officer positions. He applied for numerous positions over the course of the year. Finally, in August of 2007, Commissioner O'Brien selected the plaintiff, Stephen Anzalone, for a probation officer position in the Juvenile Court of Norfolk County. Commissioner O'Brien sent a letter to C.J.M. Mulligan, informing C.J.M. Mulligan of his decision to appoint Stephen Anzalone to the probation officer position. 6 months after Judge Mulligan received the letter of appointment, he had taken no action.
Well, Mr. Powers, maybe you're going to get to this, but when Mr. Anzalone filled out the application form, he was asked to identify family members.
Yes.
By marriage as well as by birth, and he did not include all of that information.
He did not include that, although remember that this case was allowed, the motion to dismiss was not allowed pursuant to Rule 56. It was allowed.
Is that entirely clear?
Yes, it is, Your Honor.
As I read Judge Broussard, where is it? Right at the end, page 38.
Yes, I'm aware of that.
I think it's pursuant to Rule 12C, but if there was a motion made in the alternative, which there was, and I see no reason to distinguish between the two, the papers, as they would come to me, would warrant a judgment on both.
Yes, Your Honor, I would argue, and I asked a specific question because it was unclear on the record, under which rule Judge Broussard was going to allow the motion. I would argue that that statement on the record, which is in the appendix, being as kind as possible, is ambiguous.
Did he consider affidavits?
I don't know.
Well, yes, but no, he did.
He certainly considered the Conlon.
Yes.
Is it an affidavit or something, which was to which you had made reference, correct?
No, it was submitted by the defendants.
No, but hadn't you?
No.
But he certainly considered that, didn't he?
Well,
That's one of his arguments.
he wouldn't have considered it if he ruled under 12C. He would have considered that if it was considered a motion for summary judgment. But to go back to your point, Chief Justice Marshall.
But no, doesn't it transform a 12C motion into a Rule 56 motion?
It might have. But, again, back to Chief Justice Marshall's question. On the record, the statement of the trial judge was ambiguous as to whether he was allowing the motion under 12C or 56. But if you go to the actual record of the entry of judgment, it is unambiguous. It is only allowed pursuant to 12C.
Right.
And that's in the record in its addendum B, I believe.
Tell us why that isn't a mistake.
Well,
wouldn't you say that if it was under 56B, you should have had a chance to respond?
yes. Well, yes, Your Honor. And I made that point in the oral argument that if it was under 56, I was asking for further discovery because there had not been any discovery. But to go back to your point, Justice Spina, the record is clear that it was allowed under 12C. We can't assume that that record, which says it's allowed under 12C, which is the actual record of the entry of judgment, we can't assume that that is incorrect or some kind of error on the part of the clerk. You have an ambiguous statement followed by an unambiguous entry of judgment under 12C. We have to assume that it was entered under 12C.
So looking at some of the purely legal questions involved, where do you get a private right of action under 211B, Section 8?
I don't think there is a private cause of action under that statute, and I know that's count one. I think the position of the plaintiff is that there's an action under count two for mandamus.
You know, I'm sure you're going to get to
Why is there...
That's a private right of action.
Please?
Isn't
yes.
that a private right of action?
The statute itself, 211B, Section 8, does not provide specifically in the statute for a private cause of action for a violation of that.
But if you want a mandamus, that's what it is. You're saying, I, private person, have a right to get relief under this statute. Whether you're seeking damages or mandamus, it's still a private right of action.
The distinction I'm making, Your Honor, is the statute itself doesn't provide the right. But under the mandamus theory, if there's an absence of an alternative remedy set forth in the statute, you can move for mandamus to compel a public official to do what they have a duty to do.
But you would only, I think Justice Botsford's point is you would only be able to do that if, in fact, he had a right to a right to get this job.
Well, if the plaintiff, in this case Mr. Anzalone, fell within the area of concern of the statute and he suffered harm, then you would have a right to mandamus. Our position is that he was a person of, or he had an area of concern in that the purpose of the statute to limit the power of the CJAM was, number one, to make sure that people who are appointed by the commissioner aren't just simply hung out to dry for an indefinite amount of time so that their career, such as Mr. Anzalone, is on hold. Recall, Mr. Anzalone had applied for a teaching position and applied for probation.
But isn't his, I understand, that's a reliance theory.
Yes.
You're saying the purpose of the statute is so that applicants wouldn't just hang out for some period of time?
I think the purpose of the statute, when you read it, which gives the CJAM only 14 days to reject an appointment.
Well, it tells the CJAM that, I mean, there's a 14-day requirement, but it doesn't say that at the end of 14 days there's been an approval.
It doesn't specifically state that. But what it does do is only give the CJAM limited power to reject. The power is...
Let's get to that. But it seems to me that at the end of 14 days, I don't know whether Mr. Anzalone could have done something or whether the commissioner could have done something, but possibly on the 15th day, somebody could have said to the Chief Justice for Administration of Management, I need a decision today. But that's not what your claim is. Your claim is that he is entitled to this job.
Yeah.
I mean,
well, he's entitled to have the court order the CJAM to approve the appointment.
But that's different than asking the CJAM to act within 14 days, in which he might approve or might disapprove.
Well, our position is that the statute gives the CJAM power, but gives it limited to, in scope, to time and purpose.
May I ask, so are you saying that an applicant could submit false information, but if no one catches it within 14 days, they have a right to that job?
No. It's the duty of the commissioner to determine whether the application was legitimate, whether it was fully filled out. Let me...
Whether it was accurate.
But what if the commissioner misses it as well?
Please?
What if the commissioner misses it as well?
Well, I think then the only way the CJAM can reject the appointment is if the applicant is assigned to one of those departments or district courts where he has another relative.
So if,
how about
so
the
if
power
an
to rescind?
Yeah.
How about the power to rescind in
Under
Section 9?
27.
He may have that power to rescind, Your Honor.
So then it goes through, so it's you say it's deemed approved, and then as opposed to saying I deny approval, he's saying I'm rescinding it. Is there a difference?
I don't, well, he hadn't done that, and I think if he does do that, that's a different case that we may bring.
But doesn't that go back to my original case that it's possible, I'm not saying there is, but it is possible that on day 15 or 16 or 17, somebody, possibly the commissioner, possibly Mr. Anzalone, possibly, somebody else could have said to the Chief Justice for Administration and Management, I need a decision one way or the other, That's very different from you must appoint.
Yes, it is different. That wasn't done in this case.
But let me just follow up with the Chief Justice. Under Section 10B, I think it is, an applicant for a clerk's position might be able to come in and say the 21 days or whatever, however many days it was, has elapsed, and under the specific wording of this statute, I want that door opened and I want, a light on my desk and I'm starting work. Section 8 doesn't say that. It just says he has to act within 14 days. And so the only failure is the failure to do something within 14 days. Do something now.
You're correct that the statutes are different. And this particular statute does not specifically state an outcome if the power is not exercised within the 14 days. But it's also written differently because 211B, Section 8, gives the CJAM power, but limits that power.
It does, Mr. Powers, and you correctly pointed out that we have upheld the constitutionality of it. But we also very clearly indicated in that decision that that does not take away existing powers of the CJAM, and in particular, I'm looking to the sentence that says it remains entirely within the Chief Justice Administration and Management's power to establish a set of conditions that the Commissioner would be required to follow in the appointment of probation officers, including strict compliance with all aspects of the personnel manual. And the personnel manual asked all applicants to list all relatives, not
Yes.
immediate family members, all relatives. And there's a reason for that. There's a strong public interest reason for that, that it's not only to prevent nepotism, but the appearance of nepotism. Why does that not fall fully within the power and authority of the Chief Justice for Administration and Management under 276, sections 98 and 99?
Well, because 211A limits the CJAM's power to reject an appointment, limited to non-compliance with the standards of appointment. The standards of appointment.
I understand that, but essentially you're asking us to ignore the basis on which we upheld the constitutionality of the statute.
No, I think there's a distinction, Your Honor, between the standards of appointment and the personnel standards. The standards of appointment that the CJAM has limited power to reject for, I think, are set forth in the appendix, and they are the Hiring and Policies and Procedures, Appendix 38, and those are that.
But you only rely on C and D in that paragraph rather than A through D.
Correct, Your Honor.
Why?
Because those are the appointment. Once the person applies for the position, and it's the commissioner's responsibility to make sure that the person checks out, has filled out the application, there's a query check, etc. Then he makes
has filled out the application honestly, accurately, fully. That goes to Justice Botsford's question. The commissioner, I mean, I don't know how many hundreds and hundreds of people apply for probation officer positions, but the commissioner might not have caught this.
Your Honor, and let me go back because this is important.
Right.
The affidavit of Mr. Conlon does not say that the CJAM rejected Mr. Anzalone's application because he did not include the two cousins and one cousin by marriage. It doesn't state that. It simply says, and it doesn't say when an investigation was conducted. Was, according to Mr. Conlon, the investigation conducted within the 14 days, after the 14 days, after we filed the motion, after we filed the complaint? It doesn't state that.
But within, taking the first part of your saying, it doesn't state that that was the reason for the rejection. I mean, isn't that implicit in it, the fact that it...
No, because, for instance, the commissioner could have come to the commissioner's attention that there were 2 cousins and 1 cousin by marriage that weren't filled in on the application.
Yes.
The commissioner could have decided, and I know that, but it was a mistake. For instance, I have approximately 40 cousins in the state of Massachusetts. There is no way that I know how many cousins, if any, work for the trial court.
Okay, but
So you can't be assumed to know all your cousins. You have to make a good faith effort to put those you know.
But the point is, if you look at A through D, and I think it's A that talks about the nepotism piece, right?
Yes.
The policy point that the Chief Justice is speaking about, whether he didn't know his cousins or know his cousins by marriage or not, the fact is you've got an application that is inconsistent with the personnel manual, or so the Chief Justice for Administration and Management could decide. And so couldn't the CJAM rescind this?
He may, but we don't know, A, well, he didn't rescind it, and B, we don't know whether the CJAM's decision not to approve the appointment was because of any inconsistency.
But that goes back to why, I mean, that seems
Who
to be
has the force of
implicit in
action?
the affidavit.
No, it isn't. The affidavit, if it was considered by the trial judge, it violates Rule 56.
I understand that, but just taking it on its face, you don't...
I can't take on face an affidavit that's incomplete. It doesn't say, nowhere in that affidavit does it say the CJAM made a decision based on this information.
What if we disagree with you? And we think it's implicit, that what was occurring was that the information about the other members of the family suggested a pattern of nepotism, or the appearance of nepotism. If we reach that conclusion, that's the end of the ballgame.
I don't think so, Your Honor. I don't think that the CJAM has the right to reject or not approve an appointment because of his decision that there might be nepotism in the appointment.
Well, who makes that decision?
The decision is made by the Commissioner of Probation.
So the commissioner is the one who decides whether there's
Mr.
nepotism.
Powers, I'm sorry, go ahead, Judge.
The
Or the
CJAM
appearance.
has the right, if the appointment made by the Commissioner is to a district court where there's another family member present.
So you could have 76 relatives, as long as you've got 80 courts and they're all spread out, that doesn't matter.
If those relatives are all qualified for the position, yes.
And you don't think there's any nepotism issue there?
Well, we don't know. We don't know. And that's the point. This case should not have been dismissed at this level. There should have been discovery, and at discovery, we'll find out more answers. But we don't know the answers to those questions, and we can't assume those answers.
So if I could, one more question, at least from me. Assume you're right. Assume that the CJAM has 14 days before he loses his power under Section 8 to reject the appointment. Can the Commissioner of Probation not grant the CJAM additional time and say, I'm not going to appoint this person until you give me your blessing?
I think the appointment, no, he can't give additional time after the appointment for the rejection.
Well, surely that means that he could have had a mandamus that said, I need a decision.
The problem with bringing a mandamus action against the Commissioner is the Commissioner would have said, my hands are tied, I have to get
No.
approval from
The Commissioner could have brought a mandamus action.
I don't know that, Your Honor.
But the Commissioner here in his letter said that the appointment is only to be effective upon your approval.
That's right. That's right.
And therefore, it
He
didn't
needs
happen
approval.
until the approval occurred, regardless of when it occurred.
It doesn't happen until the approval. That's correct, Your Honor.
So he has an appointment, but it's not effective. He has an ineffective appointment?
He has an appointment that has not been approved.
Thank
That's
you.
why he wasn't hired.
Thank you, Mr.
Thank you.
Powers.
Good morning, Your Honors.
Hey,
I'm
Mr.
Ronald
Kehoe.
Kehoe, Assistant Attorney General, representing the CJAM and the trial court, the defendants in this matter. This court should affirm Judge Brassard's dismissal of the action for 3 reasons, any one of which is sufficient. for an affirmance of his decision. The first is the lack of a private cause of action under Chapter 211B, Section 8, with the result that this plaintiff has no standing to come before the court under either a mandamus or a damages claim arising out of the CJAM's rejection of his appointment.
How do you read I mean, it's a very specific date, 14 days. How do you read that? Isn't that, at least in part, designed to give, if somebody has been appointed, at least by the appointing authority, give that person a chance to start the job and get on his or her way?
It could be read that way, Your Honor, but I think the complete answer to Your Honor's question is the answer that Judge Brassard gave and that we give at pages 21 to 25 of our brief. No, that's really just a matter of terminology, Your Honor. If you closely examine this Court's decision in Monaco's case, which Judge Brassard expressly relied upon, a 1966 decision, a very brief one, that case, I think, disposes of this 14-day question in its entirety, unless this Court is to now overrule Monaco's case and the earlier cases that it relied upon and the subsequent cases that have followed it. If you look at the facts recited in the Court's opinion, in Monaco's case there was a statute governing the Industrial Accident Board which required a hearing examiner to render a decision within 45 days after the close of the hearing. In Monaco's case, the decision of the hearing examiner was rendered 1 year and 3 days after the close of the hearing. In other words, it was approximately 42 weeks late. Not 6 months late, but more than 6 months, as in this case. And the Court said, yes, the legislature was concerned. They wanted to expedite these decisions. There was a problem. It was bothering them. They imposed a mandatory time limit, but they did not provide a remedy that would arise upon the expiration of the 45 days.
This statute, though, looks different. It speaks in terms of the power to reject. Those are very unique words, don't you think? You have an appointing authority, the Commissioner of Probation, and the power to reject that appointment expires at the end of 14 days. Isn't that a very different set of concepts?
The statute does not say that the power expires in 14 days, Your Honor. It says he shall have the power to reject within 14 days. But one needs to look at all of Section 8 to understand the scheme and the area of concern that it represents as an expression of legislative intent. The legislative concern is that the standards for appointment be carried out. That's the public interest that Section 8 is the relevant portion of Section 8 is designed to protect. And it's a three-step process. The first step is that the Commissioner of Probation, in making his appointment, is required to satisfy himself and to certify in writing to the CJAM that the appointment is consonant with the standards for appointment. The second phase of this three-phase process for assuring compliance is the 14-day provision. So you have the commissioner who's required forthwith upon appointment to certify compliance. You have a second stage where the CJAM within 14 days is supposed to look at it, but with no provision for what does or doesn't happen at the end of 14 days. And then you have the provision in the next section of the statute, Section 9, subsection 328, which gives the CJAM the power to rescind a non-compliant appointment without any time limit whatsoever. So you take the three of those together and you see that the legislature has created an open-ended process here for assuring at any time that an appointment be compliant with the standards.
Was this a rescission?
No, Your Honor, it wasn't posted as a rescission. It wasn't stated as a rescission. It was the record does not include a copy of any letter from CJAM Mulligan to Commissioner O'Brien, but the record does include statements made at the hearing in which it was said by O'Brien to the plaintiff that the CJAM has not approved your appointment. So we're into terminology here. But it's interesting, going back to the question of who has standing to raise an issue about this, that neither the statute nor the standards for appointment give the applicant any right to be notified even of the CJAM's action. The regulation 4.400 subsection C requires the CJAM to notify the appointing authority of his decision on whether to reject or not. And in this case, of course, that's Commissioner O'Brien. And apparently, although it's not in the record, the CJAM did send Commissioner O'Brien such a letter.
It did or did not? Did or did not?
Did, but did not state what the reasons for the rejection were in that letter.
So is your
In
position,
our view, excuse me, Your Honor.
Is your position that if the CGM rejected the appointment 2 years later, that would still be appropriate?
Well, unless the court is going to now parse the Monaco's line of cases and say, well, we're going to take it case by case and decide whether or not it's been too long, then I'd say yes, 2 years, it could be 5 years.
Let me ask you this. Do you think the either the applicant or I guess you would say the commissioner of probation this is the Chief's question to Mr. Powers maybe, on day 15, could the commissioner of probation seek a mandamus action against the CJAM, at least to take an action?
Perhaps so. If anyone had standing to mandamus the CJAM, I would think it would be the appointing authority whose decision has not been affirmed or rejected within the 14 days.
How would that work? I mean, would the commissioner of probation indeed have the power after 14 days to say, Mr. Anzalone, go to work? We haven't heard from the CJAM. Could the commissioner have said something like that and leave it up to the CJAM to rescind?
I don't know the answer to that, Your Honor. I don't think that he could have. I think that he would have to do something to raise the issue with the CJAM. I mean, in the real world, he would probably pick up the phone and say, I'm waiting for your decision. May I please have it? They would have some kind of a discussion. The rule of Monaco's case that says we won't put a straitjacket on the decision maker because of a statutory time limit unless the statute says so, that rule is a very wise decisional rule, and it's based in practical fact.
But don't you think there's a big difference between a job applicant who's making decisions about his life, about which job he's going to take, and whether you get a zoning board's decision or something like that?
I don't see the distinction, Your Honor. We had a case in Monaco's case where a widow was seeking widow's benefits under the worker compensation scheme. I don't know that this plaintiff's equitable considerations would be any more compelling than hers, or that equitable considerations come into it.
I would say especially in light of the letter that the applicant received.
From the Commissioner of Probation,
From
Your
the
Honor.
Commissioner of Probation.
Notifying him that the appointment would be effective only upon approval by the CJAM.
Yes, and in the real world, presumably, he could have called up the commissioner and said, this is what happens in the real world. I have an offer. If I don't hear by Friday, I'm going to accept that offer. And the commissioner then calls the Chief Justice for Administration and Management and says, I really want, this is a superbly qualified man, I really need a decision by tomorrow morning. I don't know what happens in those circumstances. That's not what happened here. Correct? There was
Nobody raised the issue during the 6 months, Your Honor.
Correct.
Neither the plaintiff nor the commissioner.
So I don't have to think about what happens in those circumstances. But certainly it's not as if nothing can happen. I mean, various things could have happened.
I take it we don't know what happened. I mean,
No,
we've had no discovery here. We've had nothing. This is a motion essentially to dismiss on the pleadings.
That's right. And I think on the basis of the first issue, that is the lack of standing because there's no private right of action, that's the end of the case. It's
What are the other
pure
two-
12b6 argument.
What are the other two grounds that are independent? You said there were three.
The other two grounds, Your Honor, are that under Regulation 4.304A, the anti-nepotism standard, it was well within the discretion of the Chief Justice in administering and applying that standard to say that 6 members of the same family employed within the trial court is enough. Enough is enough. We're not going to put a 7th one on. That's an apparent implicit decision that he made. Secondly, based on the Conlon affidavit, there is the failure to disclose half of the relatives. And that is a sufficient failure and a violation of 4.304B, requiring the disclosure of relatives. And it's very interesting, if Your Honors look at the application form itself. It's the same form, you may recognize it, that is used for employment applications to this court and the appeals court, as well as to the trial court. We can't have people playing games with what they disclose.
Do you think
and that application requires more than B does. B says they'll be required to disclose their relatives. The application parses it further and says, we want to know about your relatives by blood or marriage.
Do you think, though, that the affidavit, I mean, Mr. Powers' point is, if this is a 12C motion, which I think that's what the judgment says, that it was appropriate to consider the contents of the affidavit?
Yes, Your Honor, because the facts stated in the affidavit, and if you look at the hearing transcript, which is before the court as part of the appendix, those facts are not disputed. The names and dates and job titles of the relatives and the fact that they weren't disclosed on the application.
Well,
those are not disputed facts.
It's not part of the pleadings, is it?
Pardon?
It's not part of the pleadings, the affidavit.
No, the affidavit is not part of it, and that's why Judge Brassard said I can decide this under either 12C or 56. It doesn't make any difference. And
but wouldn't it be more appropriate to just, and you may well be right, that you could decide it under 12C, but it seems to me if you're going to decide it under 12C, you shouldn't, one should not consider the contents of the affidavit.
Well, the implicit in Your Honor's remark there, Your Honor, is that somehow the plaintiff wanted to engage in discovery as to something relevant to the decision of the case.
I'm just looking at what Rule 12, what Rule 12 says, that if you're going to consider matters outside of the pleadings, you convert it to a Rule 56, and then there is some opportunity for discovery. That's, I'm just looking at the rules.
The plaintiff did not seek discovery, Your Honor. He talked about it at the hearing, but there's no Rule 56F affidavit in the record.
Well, that's because nobody knew that it was going to be considered a Rule 56 motion.
But wasn't the filing made before the hearing?
I'm sorry?
Wasn't the filing by the Chief Justice for Administration made before the hearing?
Oh, indeed it was, Your Honor. The affidavit of Conlon was attached to the defendant's answer in the case, and the answer was followed subsequently by the motion under 12C or alternatively under 56, which in turn was followed by the hearing before Judge Brassard.
And so I take it what you're saying is that the plaintiff could have said, you know, if you're going to consider this, it has to be Rule 56 and I want discovery. Not clear what the scope of the discovery might have been.
That's correct.
Right?
I believe the answer with the affidavit attached was filed in November of 2008, and the hearing before Judge Brassard was, I believe, in March of 2009. So there was a period there of 5 or 6 months in which the plaintiff was on notice about the affidavit
and I
could have raised the issue.
I take it your position is it doesn't matter. It might be implicit in the Conlon affidavit, but it doesn't matter because there's been no rebuttal of the fact that he didn't list his relatives.
That's right, and there's no dispute as to who they are and what their jobs are and when they were appointed and all the other specific facts that are in the Conlon affidavit.
If I could ask you, let's assume this letter of August 29th from the Commissioner was written differently and didn't say that his appointment is effective upon your approval, but his appointment is effective upon the passage of 15 days, whereby under Section 8 I will deem your failure to reject to constitute approval. Could he do that?
It's a hypothetical question. I don't think it's clear under the statute, Your Honor. He certainly made no effort to do that. But if he did, the application would still be subject at least to the power of rescission.
Well, I understand that.
Under Section 9.
But is it permissible for the Commissioner to say, I will give you the 14 days. After that, you can rescind, of course, but I'm going to proceed with the appointment because I take the statute to say that the Commissioner has 14 days to act, and therefore I will take I will make it effective upon the 15th day.
But as Judge Brassett pointed out, there's no deemed approval language in this statute as compared to other statutes where it does appear.
Notably, Section 10B of the same Chapter 211B.
So the argument would be that the commissioner was acting ultra vires.
And that may be why the commissioner wasn't heard from for the 6 months, was that he knew full well that there was no such deemed approval effect, and he wasn't about to make an issue of it with the CJAM.
But without that, then the CJAM can do a pocket veto. He can just simply sit on it forever, can't he?
Perhaps so, unless the commissioner were to challenge him, which he has not done. That's theoretically possible. But I'd like to close by going back to Monaco's case, that is a very wise decisional rule of construction that this court has followed for almost 50 years now, and even longer than that. And it's a wise rule because it's very clear that the legislature could have prescribed deemed approval provision, as they did in Section 10B and in some other statutes. And it's also based in the reality that if you are managing a bureaucracy of the size of the trial court, and the record says there are 7,000 employees in the trial court, it's just not practical to expect that every application can be, in fact, fully vetted and acted upon and thoroughly considered within 14 days. It is an aspirational rule, if you will. It is a best practices rule that the legislature has said, try to do this in 14 days. And I'll close with this quote from the Monaco's case at page 186 of 350 Mass, in which Justice Wilkins the Elder said the following: "Until the legislature makes an express declaration that the single member will lose jurisdiction by failure to make his decision within the time prescribed, we cannot adopt the construction that is urged by the plaintiff." And so it's been clear for 45 years or more that if the legislature wanted to prescribe a remedy, that was what they should do, and that otherwise the court would do its best with the statute.
Thank you, Mr.
Court should
Keehan.
affirm. Thank you.
SJC-10617, Commonwealth versus Hernandez.
Bombastic.
Good morning, Mr.